Then we have Mr. Keithan Gardner as accused number 16. We have Mr. Malusi Booi as accused 17. We have Soraya Manuel as accused 18. Abdul Kader Davids, 19. Muhammad Amot, accused 20. Rendell Mullins, accused 21. Brenda Mullins, accused 22. We have Tuli Joy Ngip as accused 23. Nguye Nyaka, accused 24. Lona Ndoda is accused 25. And then we have Sibukazi September as accused 26, Your Worship.
Okay, so obviously accused 19. We're not going to add because Mr. Carter is not the accused of this deceased.
Bishop, I'm adding in, I do not have
Okay, so until you get the
until I get the death certificates,
so noted.
I will decide whether the state is proceeding against me. Bishop, that brings us then to the business of today in respect of case number 16/056 for 2023. Firstly, Your Worship, I've informed Mr. Peter Slala, who is on record for other accused in Bialville, that the state intends to join those charges to this case as well. Unfortunately, due to space, I didn't think it was advisable to do that today. The state will do that at a later stage. I've also informed Advocate McKernan, and that is the regional court matter of Mr. Stanfield and a number of accused on these charges, that the state intends to join those accused, which would be about 20 accused, Your Worship, to this case as well. Unfortunately, as I indicated in respect of the first matter, can't do that because of space, Your Worship. So the state's application would first be for the joinder of those cases, and then secondly, Your Worship, the investigation in respect of this matter is then incomplete, and that would relate to the letter charges, which involves accused 1, 2, 17 to then 26. In respect of those accused, Your Worship, in those charges relating to them, we still have 8 witness statements that are outstanding. State is in possession of 4 cell phones. Those records are still outstanding, as well as the reports. Then the state is in possession of 3 cell phone towers. The downloading has not been completed, so the downloading must still be done in respect of the 3 cell phone computer towers. And then, Your Worship, the state, during a search and seizure of NDT garage, obtained documentation. In that documentation, there are a number of then bank accounts, numbers, and in respect of that, Your Worship, Section 205 subpoenas are still outstanding. And then, once the bank statements are obtained, respect of all those bank accounts, a cash flow analysis must be done, Your Worship. Worship, if that is what is outstanding at this stage. Also, Your Worship, I've neglected to inform the court in respect of the other charges. That would be the Section 9 charges. I'm going to refer to them as Section 9 charges. There's also witness statements outstanding in respect of those charges because new information came to light in which the state approached witnesses. Witness statements must still be obtained for those. So in short, Your Worship, the state's application is for postponement to finalize their investigation and to join, relieve 24 accused to this matter. Worship, also the investigating officer just reminded me that during a search of Mr. Stanfield, that is accused number 1's residence, a second passport rather was found. So that must still be analyzed. The authenticity of that must still be analyzed. Those are my submissions, Your Worship, unless the court wishes to hear me on any other matter. As the court pleases. Worship, I have neglected to inform the court regarding the status of Mr. Gardner. It would be accused number 16, then to 26. In light of the fact that they are now joined to this case, state has no objection if their status remain the same. They are on bail. The only person whose status is being affected would be the status of Mr. Stanfield, accused number 1, who was on bail in respect of the Weinberg matter. That would be, I believe, 250,000 in bail. He would now be in custody as bail was refused in case number 16/0564/2023 by Your Worship. As the court pleases. Your Worship, I believe that attached to the charge sheet of Mr. Booi, all 10 accused, the bail conditions is attached. I've made copies if Your Worship wishes to attach that to 564. I've also made copies, Your Worship, of the bail conditions of Mr. Gardner, who is on 20,000 rand bail in respect of case number 4768 of 2023, Your Worship. So those conditions still remain in place, Your Worship. Yes, the court, please.
In regard to this matter 564, I haven't yet placed all the legal representative on record, so it's for record purposes because this is a lot to make sure everyone is on the same page. Accused number 1 is representing accused 1.
May it please Your Worship, for 1, 2, and 4, I appear on the instruction of Mr. Francis Michel. 1, 2, and 4.
Mr. Abrams, who's appearing for Mr. Abrams.
Please the court, Your Worship. I appear on behalf of Mr. 3, surname is Osborne. I'm from the KwaZulu-Natal Bar. Mr. Van Heeren can vouch for my credentials. He appeared the other day in KZN.
Right, thank you.
You wish also appear not to have followed the roving code down here in the Western Cape. But I understand that the proposals were withdrawn, so I'll submit that I'm not entirely addressed.
Thank you, that's fine.
Thank you.
Accused number 4. Mr. Boyson. One is Mr. Stein.
Your Worship, I'm for 4. I'm for 1, 2, and 4. May I please?
Accused 5, thank you. Mr. Brandt.
Your Worship, I appear for accused number 5, accused number 11,
Yeah?
number 13,
Yes.
14, and number 16. Thank you.
If I may just clear one thing up, because there are so many Mr. Mashele's involved in this case. My instructing attorney is Mr. Nao Mashele from Mashele Attorneys Incorporated, also of Johannesburg. Sorry, my apologies.
Right, now to thank you. Then accused number 6.
Thank you, Worship. Confirm I appear. Acknowledges. Extend my client and limit. It doesn't appear to be in
Just check Mr. Wilson, thank you. Who's appearing for Mr. Wilson, accused 7?
May it please the court, Your Worship. I confirm my appearance on behalf of Mr. Wilson, which is number 7, and accused number 8, Mr. Shakil Palston.
Surname, sir?
Mashala,
Thank you, Mr.
on instruction from Mr. Victor Mashele from VM Attorney.
Right, accused number 8.
That would be accused 8 and 9. No. Number 8. Sorry, Your Worship.
Mr. Carlson.
Sorry, accused number? We're number?
Accused number 8 is Mr. Carlson.
Yes,
Mr.
yes,
Sherry.
yes. Then we are on
accused
number 9.
Mr. Sedic.
Sadiq, yes. 9. Seems to be a lot. I'm losing track.
Right. And which other accused you appearing?
Number 9 and number 10, Your Worship.
10.
Warren Lee Dennis.
Well, going up, is appearing for accused 12.
Let me just check. I believe that could be.
Shibon.
Yes. 12.
Also. So you put 9, 10, and 12 then.
Confirm.
Who's appearing for Mr. Van der Wyk? Duncan Van der Wyk.
Court will recall, Your Worship, the charge against Mr. Van Wyk was withdrawn, Your Worship.
Previously on the other one. Thank you.
Indeed, Your Worship.
I see that. Right. Okay, the rest 17, 18, 19, that is the case that was just before. I've got all the legal representatives. Right, there's an application by the state first and foremost for joinder of more cases, and then also an application regarding further investigations, especially with regard to the case that is currently before court. I will hear the attorneys and advocates now regarding this request. Mr. Attorney, thank you.
May it please you, Your Worship, can we just inquire from the state how long they anticipate this investigation? We've been addressed at length as to what is outstanding, but we're not aware of how much time the state has requested. Can we ascertain that first?
Yes.
Thank you.
Advocate?
Your Worship, I cannot tell this court exactly how long this investigation is going to take. As I indicated to the court, there are 4 cell phones that must still be downloaded. Then it must be analyzed, the data. That is the same in respect of the 3 computer towers that must still be downloaded, and the information must still be analyzed. And then, as I indicated to the court, there must still outstanding is a cash flow analysis. So that is going to take some time. So I cannot stand here and tell the court that it's going to exactly take 2 months. What I can inform the court is that I've been in contact with the second investigating officer, Captain Pakia, who's dealing with the commercial side of this investigation. The witnesses that is outstanding, the witness statements, Your Worship, that is outstanding. Some of the witnesses are in Cape Town, and there are also witnesses outside of the province. So that is going to take some time. Worship, I'm going to request for the matter to be postponed till the end of January. I believe all the parties, that is myself, Mr. Hendricks, Mr. Markey, and Mr. Mashala, didn't inform the court that we still do not have a magistrate for the bail application of 6 of the accused. So that is also going to take some time. The bail applications of the 6 accused are still outstanding, Your Worship. It's not been finalized. As I indicated, we do not even have a magistrate or a venue for those bail applications, Your Worship. So unfortunately, I cannot say with certainty that the investigation will be finalized at the end of January, and whether the bail applications have been finalized or will be finalized. Those are my submissions, Your Worship.
May it please you, Your Worship, with greatest respect, that's one of the vaguest answers I've ever heard. This court has been seized with accused 1, 2, and 4's matter for a year, an entire year. In April, the investigation against accused 2 was declared complete. We are still not in receipt of any of the docket. We cannot prepare. Accused 2 is now a passenger on what essentially the state has added another matter that is seemingly prematurely before court. They're investigating it, they don't oppose bail. That matter takes up court time, and now it's been added to an existing matter that's a year old, and this court is asked to judicially decide how much longer we should be sitting in court 16. And with respect, it's a very difficult position for this court to be in, because this court is not armed with any concrete information. On the one side, you have clear prejudice to multiple accused in a matter where the investigation is complete. In fact, the matter against accused 1 was declared complete, I believe, in August. And now they're hamstrung in another matter where we don't know. Because that is the answer, we don't know. Please throw a dart into the dark and see where it lands. With respect, January is an outrageous affront on the rights of the accused. Now, this court at some point needs to draw a line in the sand and say to the state, you've got all the resources, 8 witness statements don't take longer than 2 weeks. I understand that the other matters may take longer than a few weeks, but essentially this court's been asked to keep people in custody for what's going to turn into 18 months. So with the greatest respect, this aspect needs to be put in concrete so we understand how much longer we're actually going to be appearing in front of your worship. In fact, your worship, I begged your worship to transfer us out of here. That was earlier this year, and the court agreed that we're a reception court, this matter must proceed, but clearly it's not. So in terms of the state justifying why they need a postponement, I believe they've certainly met that test. But in terms of the length of time, it's wildly inappropriate. Those are my submissions. May I place on record, Your Worship, that apparently my clients see me through the clerk, Mr. Rifle's cell phone, and I'm indebted for him to allowing us to use his cell phone. But I can also hear on this device that multiple people are saying we can't hear you. So I'm not sure who that is. It's not clear from any of the technology before me. I can only see my white client. But in terms of them hearing me, clearly it's not working.
Thank you, Your Worship. Your Worship, insofar as accused number 3 is concerned, we should be talking more about separations and joinder. He has now been in custody for 14 months. None of these additional cases apply to him. His rights seem to be ignored in the face of the state simply taking a shotgun approach and throwing a barrage of charges at all sorts of people. Section 35 allows an accused to have a fair and speedy trial. Well, there is no trial if he's sitting as a passenger watching multiple accused being added, multiple charges being added. They have no bearing on him. He has no interest in those matters. Your Worship, under the circumstances, I respectfully submit that after 14 months, nobody should be hearing the words from the state of the matter needs to be investigated further. And while we're about it, we might have another 20 accused that we want to simply throw into the mix at some point. With respect, Your Worship, that simply shows obfuscation and a clear intent on the part of the state to deny any of the accused the right to a fair trial. Your Worship, in addition there, my client was Afrikaans speaking. I had to consult with him in Afrikaans the other day. There is no interpreter who is able to interpret the proceedings which he can't hear anyway. So this is actually a gross and egregious violation of the accused rights. Thank you.
Mr. is present, it speaks Afrikaans.
Dus correct so jy was nie lang weet as jy in Afrikaans.
Mr. Andres, you can interpret to the advocate's client what he wants to say.
That's accused number 3.
Mr.
Your Worship, but then also Mr. McKinnon touched upon it, but we sit in a situation where we can't take instructions from the accused. This is an important application brought by the state, seeking further delay in the proceedings, and we can't even take instructions.
I hear you. I will deal with that just
Thank
now.
you.
I'll deal with it every time, but I will do it once more. Right. Next, Mr. Mark.
Your Worship, I also share with the sentiments of my colleagues in relation to this matter. All intents and purposes, Your Worship, had it only been accused number 1 to 14 before court, surely this matter would have been transferred to the regional court by now. The court will note that on previous occasions, Your Worship, the court has marked that matter for investigation final, Your Worship. Now it happens that every time we come to court, new accused are added to the matter. Those investigations are not complete, and somehow it affects all the other accused. Your Worship, it has to come to a point where the court has to say enough is enough. This is purely abusive to the rights of patients in this matter, Your Worship. And it is my respectful submission that it is a premature joinder, Your Worship, taking into account we're dealing with a matter which involves a specialized unit which would require Section 205 applications and analysis. That investigation, Your Worship, is known to take very long. My client, Your Worship, the investigation was finalized in as far as August already, Your Worship. It is an injustice that court cannot ignore. A request for postponement until January over a matter that is investigated by specialized units, Your Worship, is absolutely outrageous. Should the court be inclined to grant the state another remand in this matter, Your Worship, such remand should be more final. And that should serve as incentive to the state to actually pull up the socks and do what they need to do. Thank you, Your Worship.
Noted, sir. Thank you.
Thank you, Your Worship. I just want to know if my client can actually hear me this time, Your Worship, because I've said this earlier before. He indicated that he cannot hear me. May I just ascertain?
Yes, you may.
Can you hear me? Can't hear me. Can you hear me now? Can you hear me now? Can you hear me? Yeah, Your Worship, as the court can see, this is not working. The fact that my client cannot hear me, the fact that he cannot take instruction, is a gross infringement of the act. It's absurd. How is he supposed to engage in legal proceedings adequately without being able to do that, without them hearing the matter? Flies in the face of the Section 55 rights. That's one. The sentiments of my previous colleagues that have addressed this court, I confirm and stand by these sentiments. The fact that my learned friend is in the state is adding charges which now allow our client, my client specifically, to be joined in these proceedings, where his matter has been, the investigation has been finalized in August already, is crazy. We should be able to be going to the various to a higher court at the moment. The fact that our client also found a bail court is absurd. My learned friend has stated to the court that we don't have a bail magistrate or a venue. That's another. So I object to my learned friend's request. My learned friend stating that Mr. Martin stating that the matter be not final. I'm not aware of it. I object outright to my learned friend. I've requested further particulars since August already. My learned friend has undertaken every day that he will give me these further particulars so that I can ready my mind for bail application, Your Worship, because I need, with my client's charges, I need those further particulars to be clear adequately for bail. Yet I haven't been placed in a position to do that. So, to be tapped on and almost saddled with other matters that have not been finalized, other matters the investigation has not been finalized, that's absurd.
Mr. Hendricks, before you sit down, have you approached the senior magistrate in regarding to
We have.
And what was his feedback?
We were supposed to have a date today.
The date?
Oh, well, we arranged the dates on the last occasion. We were supposed to have a court and a magistrate today.
That can be arranged in 5 minutes because he is awaiting basically feedback from me, so that won't be a problem to obtain magistrate.
And with respect to Your Worship, my learned friend undertaking to be first particulars for the last month and a half. He says he will have it today, Your Worship. I just wanted to confirm on it today.
I will ask him just now. Thank you, Mr. Hendricks. Yes.
Your Worship, I don't think I could even know my address.
So what we can do, I can adjourn and Mr. Bosman, we can make sure that people is standing inside of the client and then they can affirm whether they're here or not. Or maybe there's some adjustment needs to be done so that they can hear. So that won't be a problem, so that everybody knows what is happening in court, because they have a direct link.
Your Worship, may I propose, Your Worship, that we now request the correctional officers at the various centres who are responsible for the accused persons to ensure and to assist
Exactly.
with the proceedings. In fact, they were requested to assist with the proceedings to ensure that all the accused hear and see the proceedings, Your Worship.
Indeed. I will now
From, I believe from our side, and that I was informed from our side, Your Worship,
Yeah.
there's no problem. It seems that the problem is at the various correctional centres.
Mr. Bosman, check for the laptop as well, because this is also the item.
Also, Your Worship, can we request all the other accused to remain quiet and just raise their hands if they have a question or they have something to say to their attorneys?
I will do that when I come back.
As the court is.
Sorry, Your Worship, I apologize. If that is going to take place, can we ask that all the media are then excused?
Say again?
Can we then ask that all the media are excused?
Why?
Or it would be us discussing with our clients, if I understood correctly.
I've already addressed this matter before in regard to ADR and in request discussing with, are you talking about in the interim?
Sorry, I might have misunderstood. I understood that the court was going to adjourn to allow us to confirm with our
So do you
clients
want
what
to
has
speak
been
to
said.
them? That's fine.
And if that is the case, it would obviously be
That's
provision. We'd ask that
understandable.
other people be excused.
That's
That,
understandable.
May I
So
please,
the
Sir?
media just needs to clear the court so when the attorneys speak to their clients, that will be privileged and private.
Your Worship, and furthermore, if perhaps we could be given a bit more space.
Yeah, they
It's
can do it
absolutely
now.
ridiculous.
That can do it now. That's
Thank
why
you.
I've got ADR service, because we can't accommodate 50 people. For the gents.
Frank, what I wanted to know from
That's what I wanted to do. He's now inspector of the new chapter. That's
What do you want to do?
I just want to hear. Inspector of the new chapter. My client is your client again? 26. The only charge against is corruption, receiving 50,000 rand. That's the only charge.